According to a widespread opinion in legal theory, Hart's concept of law struck a fatal blow to legal realism by exposing the supposedly serious weakness of its account of legal and especially judicial reasoning. According to this widespread view, indeed, by adopting Holmes' definition of law as prophecies of what the courts will do in fact, the realist approach ends up with a rather ludicrous account of judicial reasoning. According to this widespread view, indeed, by adopting Holmes' definition of law as prophecies of what the courts will do in fact, the realist approach ends up with a rather ludicrous account of judicial reasoning. As Brian Leiter pointed out, such a definition, in equating the concept law with to what the courts will do, seems to involve the bizarre implication that while a judge is confronted with a case, rather than assessing what the law provides on that specific issue, she is actually trying to predict her own decision. However, despite the wide consensus surrounding it, Hart's criticism seemed to miss its target. Indeed, his assessment overlooks the pragmatist influence that we can track in many works of realist literature, especially with regards to the framing of concept and definition. Let's take, for example, Felix S. Cohen. Examining Holmes' definition, Cohen emphasized that, rather than by its truthiness or falseness, it should be assessed by its usefulness. Different definitions, indeed, could be framed and adopted according to different purposes, and the choice between them is purely a matter of expedience and convenience. More broadly, Cohen states that in various occasions that the value of concept, definition and theories lay precisely in their capacity to orientate the investigation toward new sets of problems, raising new questions to highlight, I'm quoting here, facts and issues which formerly were considered unimportant, indecent or self-evident. Concept and theories are therefore heuristic instruments, whose value must be tested based on the consequences of their adoption. It is important to highlight that such an approach to conceptual issues shares many similarities with those we found in the pages of classic pragmatists. William James, an author indeed often quoted by Cohen while reflecting on epistemological and methodological problems, is a relevant example. Just to quote an interesting passage, in The Sentiment of Rationality, 1879, James described a conception as, I'm quoting here, a teleological instrument. It is a partial aspect of a thing which, for our purposes, we regard as its essential aspect, as the representative of the entire thing. In comparison with this aspect, whatever other properties and qualities the thing may have are unimportant accidents which may, without blame, ignore. Of course, when the purposes of our inquiry varies, changes also the essential aspect in which the conception we build is based. Therefore, James observed, and again I'm quoting, a substance like oil has as many different essences as it has uses to different individuals. One man conceives it as combustible, another as a lubricator, another as a food. The chemist thinks of it as hydrocarbon, the furniture maker as a darkener of wood, the speculator as a commodity whose market price today is this and tomorrow that. Another prominent realist, Carl Llewellyn, in one of his seminal papers devoted to the theoretical methodological program of a realist jurisprudence, considered concepts as thinking tools, built to classify some data according to specific criteria of relevance and in relation to a specific purpose. The conceptualization and classification of phenomena requires different selection procedures depending on the object of the investigation. It implies building emphasis and creating stresses, obscuring some of the data under observation and giving fictitious value to others. In the light of such an approach to concepts, it is not surprised that Llewellyn displays a skeptical view toward the utility, not to mention the very possibility, of building a unique and all-encompassing concept of law. Even if one concedes that it will be possible to frame such a concept, indeed, trying to fulfill a vast amount of diverse and often opposite purposes, it would end up achieving none of them. For this reason, instead of elaborating an all-encompassing concept, Llewellyn prefers to set several focal points that can guide the study of legal phenomena. The instrumental and heuristic view of concepts as tools for inquiry adopted by Llewellyn shows relevant traces of John Dewey's work. Especially in the first chapter of the second revised edition of Experience and Nature, Dewey outlines, and I'm quoting here, an honest empirical method in order to improve, also in philosophical and social science investigation, the cooperative process toward controlled consensus, which is typical of the hard science inquiries. One of the tenets of such a method is precisely the programmatic openness and candor about the emphasis, selection, and choices that, given the objects that guide it, every operational knowledge involve, and that, if concealed, engender fallacies and methodological problems in the investigation itself. These few examples, although sketchy of course, are nonetheless sufficient to cast serious doubt about the aptness of Hart's criticism. Definitely, American realists did not formulate claims about the nature of law, nor were they trying unsuccessfully to elaborate an ultimate encompassing concept of law. Rather, they were engaged in assessing the costs and benefits, the theoretical convenience, as Cohen would have put it, of the bad man approach elaborated by Holmes for the investigation of legal phenomena. Such an approach, through the realist analysis, appeared to be especially useful in casting light on relevant features of legal interpretation. From the point of view of the bad man, interest in the prediction of what the courts will do, legal interpretation is a practical, goal-oriented enterprise. And even more importantly, it is a structurally non-cooperative enterprise. Lawyers have always attained a whole set of interpretative and argumentative methods to interpret a legal provision, a legal text, according to the meaning which better suits their client interests and claims. As Llewellyn pointed out in a famous work, I'm quoting here, in the field of statutory construction there are correct, unchallengeable rules of how to read, which lead in happily variant directions. It is especially relevant to emphasize that such methods have been elaborated in the legal culture by the legal culture as tools, or rather weapons, meant to oppose each other, to attack and counterattack. For this reason, it is profoundly misleading to equate legal interpretation to ordinary communication, trying to capture both within the same theoretical framework. It is likewise misleading to reduce the sources of legal indeterminacy to the vagueness and open texture that mark ordinary language, as Hart, in his theory of interpretation, suggests. To have a wider and more detailed picture of legal indeterminacy, we must consider the structural elements of interpretation of legal texts mentioned before, opposite interests of the parts in the lawsuit, the whole sets of mutually opposing interpretative techniques elaborated by legal culture, but also the opposite intuition of justice and normative doctrines of interpretation adopted by judges. In the light of these elements, as Riccardo Guastini pointed out, we can understand that lawyers and jurists have the tools to make equivocal even those texts whose interpretation in non-legal contexts will probably be uncontroversial.